Welcome to part one of chapter nine, Intellectual Property from the Legal and Ethical Environment of Business by Terence Lau and Lisa Johnson. This is Professor J. Kent Gregory, and I'll be taking you through parts one, two, and three. So intellectual property, also known as IP. Some terms to keep in mind as we go through this. Reverse engineering. This is the process of tearing down a finished good to its components to kind of figure out how it was designed or manufactured. And you all probably already know that. IP is intellectual property. It's intangible and it's the product of human ingenuity, human intellect, and it's protected by law. And then, of course, to infringe. That's to step on or violate someone else's property rights. So it's important to think of, IP, intellectual property, as property, much like we had discussed in a previous chapter. So intellectual property regimes, this is from the book, and this is a great way or a great encapsulation of the four different types. So trade secrets, patents, trademarks, and copyrights with the origins, how you obtain them, does the public know them, and what does the protection cover? So, for example, let's see here, trade secret covers anything a company wants to keep confidential. So this is a secret, public doesn't know about it. So it's almost like it's the recipe to Coca-Cola or the ingredients or how to make up McDonald's secret sauce. Then there are patents. This is a useful process, machine, articles of manufacture, or compositions of matter. And something that's, well, we'll talk about these as we go along. And there are trademarks. So these are words, names, colors, sounds, symbols, and copyright. So this is works of creativity and authorship. So you can think about, art and the word. So uh, some more things to keep in mind. The United States Patent and Trademark Office, the USPTO. This is a federal agency. It approves patent applications and officially grants trademark status to qualified marks. So this is not a law. Only a court can finally determine the validity of a patent or trademark application. And of course, that only comes into play if the patent or trademark is challenged or if the recipient of the patent and trademark wishes to enforce it. Uh, so a few things to keep in mind. The copyright clause. This clause is within Article 1, Section 8 of the U.S. Constitution, and it authorizes Congress to pass laws protecting intellectual property. Now, the Constitution only addresses copyrights and patents, but modern IP law includes things like trademarks and trade secrets. The copyright clause, this is funny. So it's not the Santa Claus, but the copyright clause permits the government to protect certain products of the mind. And it allows the government to create sort of a special kind of monopoly around IP. And then there are two sides to the monopoly. The producer, who wants the monopoly to last as long as possible because the producer can control the price and derive a greater profit. And then the consumer, who wants the monopoly to end as quickly as possible so that the consumer can pay competitive prices for the good or service. More about the copyright clause. So the copyright clause is intended to do this, which is to strike a compromise between producer and consumer by stating that the Congress can grant the monopoly only to promote the progress of science and useful arts. So that's, two important things, science and useful arts. And whatever monopoly Congress grants has to be for a limited time. And then kind of a corollary to that is the public domain. This is any intellectual property not protected by law and freely available for any member of the public to use. So you think of works of art or works of music by, let's say, Beethoven, Mozart, things like that. Copyright clause does not state how long the monopoly can last. it leads that task up, or leaves that task up to Congress. So patents. What are patents? Well, there are three types. And first, this is a patent is a federal grant, a federal right rather, granted to inventors for processes, machines, and compositions of matter. And there are three types. So there's the utility patent. This is the most common type, and it's awarded for inventions or improvements to methods, processes, machinery, and compositions of matter. There's a plant patent. This is a unique patent right granted to inventors of new forms of plants. So we think of this as genetically modified organisms. So think of some of the soybeans and corns, things like that out there. The book mentions the fact that Monsanto has genetically engineered certain plants to be resistant to its Roundup, which is an herbicide that Monsanto makes. And then the patentee is the holder of a patent. So more about patents. The patent exhaustion doctrine states that the initial authorized sale of a patent item terminates all patent rights to that item. The first inventor to file, so the first applicant to file for a patent on a particular invention is eligible for the patent, regardless of who first invented it. And the United States switched to this in fairly recent times in 2013. And interestingly, in the United States, as opposed to other countries like Canada, living things are patentable. And then the patentability of life forms is a very contentious issue. The book mentions the specialized, the genetically engineered mice that are designed to grow cancer. With respect to limiting patent rights, some governments have declared national health emergencies in order to permit those governments or permit themselves to force drug companies to license the formula to generic drug makers. So this is a type of licensing called compulsory licensing. The USPTO grants property rights to patentees within the United States, its territories, and possessions. And patent law is actually very complicated. So attorneys who prosecute patents, meaning who pursue patents, must have an engineering or science background and pass a separate patent bar exam. And while the application is pending, the applicant is permitted to use the term patent pending in marking the product to warn others that a patent claim has been filed. So it's almost like state. The U.S. Supreme Court has routinely ignored patent appeals until recently because of the increase in the number of business method patents, which has led to a dramatic increase in patent applications. But what are business method patents? So patents granted for a way of doing business. For example, the one-click patent. This was a patent granted to Amazon.com that allows customers to use one mouse click to purchase items. Outside the United States, a patent granted by the USPTO does not protect the inventor's interest in that property. So the inventor's interest in the property or the rights granted by the patent ends at the boundaries of the United States. And if someone possesses the patented object without permission from the patentee, then that person can be said to have infringed on the patent owner's rights. And then finally, in part one, patent infringement. It's a violation of the patent holder's rights. Some defenses to that, the patent infringement claim, they challenge the validity of the patent, demonstrate the patent was incorrectly issued if prior art proves that the claimed patent is not novel. And patent holding company, who also known as patent trolls. These companies are companies whose sole purpose is to acquire patents and then to go out and sue potential infringers. So that brings us to an end of part one. Thank you for joining us, and we'll begin again with part two.